When you want to screen share, just announce what you're doing. We'll assume that the jury can see it. If and when it's admitted, we'll assume the jury does not see it if you're going through the process of getting an exhibit admitted. So we'll assume all the formalities are handled automatically properly, but don't ask permission to screen share something. Just announce what you're doing so we know what you're doing. When you make an objection, just say objection. I'll call on both counsel for the important objections that are likely to come up in this trial and hear you both, but don't keep talking. Zoom does not work very well if two people are talking at the same time. So just say objection. I'll call on you and we'll sort it out with one person at a time talking. So I think that covers some of my pre-trial matters. I'm Bill McGinnis. I'm an attorney here in Rochester, Minnesota. I judge high school and college mock trial all the time, including the national tournaments for both high school and college. And if anybody even hints there's a mock trial tournament, why, I'll sign up to judge. So I'm a little obsessive compulsive on that. I enjoy it because I think it's such a great activity. There are so many different skills involved in mock trial, and they are all relatively important to the kinds of skills an attorney would need, but they're also transferable to so many skills you need in just any occupation these days, or career calling you'll find, not just law. So whatever it is, we wish you the best. So we'll begin with pretrial matters. Plaintiff counsel, if you'd begin with introductions and any pretrial matters.
Of course, Your Honor. Good afternoon, Your Honor. My name is Ella Judd, counsel for the plaintiff, Ethel Marks. Today, I'm joined by my co-counsel, Lyra Packman.
Good afternoon, Your Honor.
And Your Honor, would you like us to do preliminary matters now or after defense has stated their appearances?
Go ahead with your preliminary matters and we'll call on defense counsel for the same in a moment. Go ahead.
Your Honor. But first, we'd like to invoke Rule 603 that all witnesses be constructively sworn in.
All witnesses are sworn in.
We'd also like the court to note that all exhibits have been pre-marked as 1 through 27, and we ask that they retain those labels regardless of the order that they're entered into evidence.
Granted.
And finally, we'd also like to note that exhibits 1, 22, and 23 have been pre-admitted into evidence and can be used during the trial at any time.
Understood.
With that, Your Honor, plaintiff is ready to proceed.
Defense counsel, please make introductions and any preliminary matters.
Yes, Your Honor. Good afternoon, Your Honor. My name is Pandey. Today, I'm joined by my colleague, Rishi Subramanian, who will be my acting second chair. Together, we represent the defendant in today's case, Sonny's Rooftop Bar. We're also joined by the owner of Sonny's Rooftop Bar, Sonny Method.
Good afternoon, Your Honor.
Your Honor, we have a few housekeeping things to get to. First of all, pursuant to Rule 615, we move to sequester Morgan Levin from opening statements and the trial until she's called to testify.
The witnesses are sequestered.
We expect to be referring to the deposition of someone who's not in court today, Stevie Redger. Stevie Redger is unavailable pursuant to Rule 804A, and pretrial number 21 says that both parties have agreed that the deposition is authentic, and we'd like the court to take notice of that.
Very well, but any time you spend with the deposition will be taken out of either your direct exam time or your cross-exam time. So any time you spend with a deposition is on the time clock.
Yes, Your Honor. With that, the defense is ready to proceed.
Other thing is, it needs to be brought forward before the case is closed. In other words, if your case is closed, it's too late, or if the defense case is closed, it's or prosecution or plaintiff case is closed, it's too late. You have to do it while your case and the record are open. Anything else from either counsel?
No, Your Honor.
Plaintiff is ready to proceed.
Thank you. Let me check my ballot. As I said, we don't get as many comments from me while I'm presiding, simply because I'm paying pretty intense attention to the trial, but we'll find that you can ask me questions at the end of the trial, particularly about any ruling I made. Otherwise, my comments tend to be briefer, and that's the good thing. The scoring judges may have an opportunity to do a little more commenting. Let's all switch to speaker view and we'll do opening statements. Time keepers, you may use the chat function for time messaging, or if you do have time cards, you may come on screen with time cards, especially if somebody runs out of time and you have stop time. So you may come on screen if you have a stop time issue, but otherwise you may use the chat function. Very well. We should all be in speaker view. Plaintiff counsel, come on screen and deliver your opening.
Yes, Your Honor. They ignored the obvious. On March 24th, 2019, the body of a 19-year-old girl, Jessica Marks, was extricated from a car in a ravine. Her blood alcohol content was twice the legal limit. And while her car sat in that ravine, the people responsible for her intoxication sat comfortably in their rooftop bar, closing up shop. Those people had a responsibility, a legal duty to her, to stop serving her alcohol when she became too drunk. But when Jessica Marks was stumbling around and slurring her words, they just served her more alcohol. They ignored the obvious. Today, we're here to hold the bar that served Jessica, a minor, responsible for their actions. To do that, as the plaintiff, we've brought a claim of wrongful death against the defendant, Sonny's Rooftop Bar. We have the burden to prove our case to be true, more likely than not. Now, it's undisputed that Ms. Marks was a minor, so all that's left to prove is that the defendant saw the obvious signs of intoxication and continued to serve Ms. Marks, which was a substantial factor in her cause of death. We'll meet that burden because the evidence will show that those signs were obvious to the defendant, but they chose to ignore them. First, you'll hear that the defendant saw the signs of obvious intoxication. You'll hear about all the drinks they served her over the course of almost 3 hours. Wine, hard seltzers, beers, shots. You'll hear that just minutes after she left that bar, her blood alcohol concentration was 0.16%. That's twice the legal limit for an adult in the state of California, and 16 times the legal limit for someone Jessica's age. Now, you won't just have to hear about it. You'll get to see for yourselves how Jessica was acting that night. You'll see a video of her taken almost an hour before she left that bar, where you'll see just how obvious those signs of intoxication were. You'll hear that the defendant saw Jessica's behavior, and not even halfway through the night, and said that they should stop serving her. But members of the jury, you'll learn that they never stopped serving Jessica Marks that night. Even though they saw the signs, they ignored them. They continued taking orders, continued making drinks, served round after round to Jessica's table from 9 p.m. to near midnight. Sonny's Bar had a responsibility to stop serving an obviously intoxicated minor. But they ignored the obvious. And that's why at the end of this trial, we'll ask you to hold the defendant liable for the wrongful death of Jessica Marks. Thank you.
Thank you, counsel. Defense counsel, if you would come on screen and deliver your opening, please.
Yes, Your Honor. Choices. Just a few moments ago, Ms. Judd came before you and chose to tell you a story that Sonny's Rooftop Bar ignored the obvious. And in that story, there is one thing we agree on, that Jessica Marks' death was a tragedy. There's no doubt about that. No one should have to go through what the Markses are going through right now. But what Ms. Judd chose not to mention in that story was, as the evidence will show, Jessica Marks's signs of intoxication weren't obvious. So Sonny's rooftop bar wasn't ignoring anything. What Ms. Judd chose not to mention was that Jessica Marks's own choices from that night were what led to her death. Choices. But today, the plaintiff has chosen to say that it was Sonny's rooftop bar's actions that led to Jessica's wrongful death, a serious accusation that they have the burden of proving. They have to prove to you by a preponderance of the evidence that it's more likely than not that Sonny's rooftop bar kept on serving Jessica alcohol even when she was obviously intoxicated, which contributed to her death. But they won't be able to meet that burden because, as the evidence will show, it was really Jessica's own negligence that resulted in her death. And that's why we're choosing to respond with an affirmative defense of comparative negligence, in which we'll show you that it was more likely than not that Jessica Marks's choices to use a fake ID, her choice to illegally purchase drinks, and her choice to get behind the wheel were what caused her to get into that accident. So throughout the course of today's trial, we're going to answer three questions whose answers will not only prevent the plaintiff from meeting their burden, but also prove that Jessica Marks's death occurred because of her own wrong choices. First, why did Sonny's rooftop bar choose to serve Jessica? The second, what is Morgan Levin choosing to hide from you? And third, whose choices ultimately led to Jessica's death? Let's start with that first question. Today, you'll hear from Sonny Mem, the owner of Sonny's rooftop bar. And she'll tell you that she made the choice to serve Jessica Marks because she wasn't showing any of the symptoms of obvious intoxication. In fact, we'll show you testimony of another witness from that night, someone not affiliated with the bar at all, who will tell you that Jessica didn't seem obviously drunk either. Which then begs the second question. Why is it that Morgan Levin, the plaintiff's sole witness, is the only one claiming that Jessica Marks was obviously intoxicated? What is Morgan Levin choosing to hide from you, members of the jury? You'll learn that Morgan Levin's testimony is riddled with flaws, that Morgan Levin is testifying for the plaintiff only after they threatened to sue her, and that it was Morgan Levin herself who was drunk that night, not Jessica Marks. And finally, the hardest question to ask ourselves: whose choices ultimately led to Jessica's death? Because today the evidence will show that from the very moment Jessica decided to get a fake ID to purchase alcohol illegally, to her intentional drive to Sonny's rooftop bar to drink illegally, to her drinking illegally, to her getting in the car to drive away illegally under the influence, it was and only could have been Jessica Marks's own choices. Now, I've talked a lot about choices in the past few minutes, but at the very end of today's trial, I'm going to come before you again and ask you to make a choice. To choose truth or distortion, fact or emotion, justice or vengeance. And when that time comes, we are confident you will make the right choice and find Sonny's rooftop bar not liable. Thank you.
Thank you very much, counsel. Let's all switch to gallery view. And plaintiff counsel, you may call your first witness.
Yes, Your Honor. A plaintiff calls Morgan Levin.
Levin is called.
May I proceed?
Let me make a note here.
Of course, Your Honor.
I like to keep track of all the participants as I keep notes here, and I just get that written down. Thank you very much. Counsel, you may proceed.
Yes, Your Honor. Good afternoon, Ms. Levin. Please introduce yourself to the jury.
Hi, my name is Morgan Levin.
What do you do for a living?
Right now I'm a student at UCLA. I do biology.
Ms. Levin, how are you involved in today's case?
I was there when my best friend, Jessica, died that night.
You say Jessica, are you referring to Jessica Marks?
Yeah, I was with her and it's taken me a lot to get over it. I'm sorry. Yeah, I was with her.
Well, Miss Levin, how did you know Jessica Marks?
We were best friends. We met in junior high and we had the same birthday, so we thought that was funny and we did everything together. And even when we left for college, we stayed in touch.
Where were you on the night of March 24th, 2019?
I was with Jess. We went to a bar, Sunny's rooftop bar.
Well, I need to ask you about the details of that night. What time did you arrive at Sunny's bar?
At around 9 o'clock.
And how many employees did you see there?
There were two. One, the owner, was serving up top. I think her name was Sunny, and the other downstairs.
Well, how often did you interact with Sunny?
Maybe 8 to 10 times. She came and she took our orders and she served us.
And did she serve you any drinks?
Yes,
And who was paying for those drinks?
I was. I was treating Jess because it was her first time coming to LA and I wanted to take her out.
Would you recognize a photo of your receipt if I showed it to you?
I would.
I'm showing the witness what's been marked as Exhibit 17. Do you recognize this, Miss Levin?
Yeah, that's the receipt that they gave me.
Is it a fair and accurate copy of that receipt?
Looks the same, yeah.
Your Honor, plaintiff offers Exhibit 17 into evidence.
Counsel, is there any objection?
Objections from the defense, Your Honor.
The exhibit is received.
Ms. Levin, I want to talk about who drank the items listed on this receipt. Could you tell us who drank what?
We ordered the wine together, but I only had a glass. I didn't like it very much. Jess had the rest. Jess also ordered the 3 White Claws. I don't like those. And I ordered the draft. She ordered the beer can. We each had a green tea shot.
Did you have any drinks that aren't listed on this receipt?
I didn't know.
Do you know if Jessica had any drinks not on the receipt?
Yeah, she did. At some point, she brought a drink from downstairs and she came to our table and sat down.
Did you ever think that Jessica had had too much to drink that night?
I did. When we were there,
Objection, Your
she.
Honor.
Counsel, did you object?
Yes, Your Honor, I did.
What is your objection, counsel?
Your Honor, I believe the question, did you ever think she had too much to drink, is vague and quite frankly, on the verge of ambiguous, because counsel hasn't laid out what that means, what too much means, whether it was in terms of how Jessica was acting as a result of those drinks, whether that means a certain number was too much. I asked that counsel clarify what counsel means by that.
I'm going to sustain the objection. Counsel, you may inquire into the subject you're interested in, but you're going to have to rephrase your question.
Yes, Your Honor.
Move to
Ms.
strike that from the
Levin.
record.
We'll strike.
Ms. Levin, did you see anything from the way Jessica was acting to indicate she might have been drinking too much?
I did. During the night when we were at the bar, she was stumbling around a bit. Her eyes were bloodshot. When we spoke to each other, she was slurring her words more as the night went on.
Is there any specific instance where you thought she looked a little drunk?
There was. We were going down the stairs and heading to the restroom, but I was behind her on the stairs and she was stumbling, almost fell flat on her face, but the bar owner, Sunny, caught her.
Do you remember what time it was that she fell down the stairs into that bar owner?
Around 10 o'clock.
And how did Sunny react?
She turned around to the bartender and said, "Whoa, Frankfurt, we might need to cut this one off."
And did she cut Jessica off?
No, they kept serving.
Ms. Levin, I want the jury to get a visual of how Miss Marks was acting that night.
Excuse me for interrupting. Timekeeper, if you'd stop for a second. I heard somebody coughing and it wasn't anybody on screen. I see in my participant list that a spectator has their microphone off. May I ask the spectator in question to shut their microphone off? Sorry to interrupt, but and timekeepers give them credit for that. Thank you. Counsel, you may proceed.
Yes, Your Honor. Ms. Levin, would you recognize a video of Ms. Marks if I showed it to you?
Yeah, I know I took one that night.
I'm showing the witness what's been marked as Exhibit 10. Ms. Packman, can we get Exhibit 10 up on screen? Ms. Levin, do you recognize what's on screen here?
Yes, that's the video I took of Jessica. I've watched it a few times because it's the last video I have of her.
And do you remember what time you took that video?
Sometime around 11, it was towards the end of the night.
And does this video depict how Jessica was acting that night?
It does. It shows how she was acting all night.
Your Honor, we offer Exhibit 10 into evidence.
Counsel, is there any objection?
Yes, Your Honor, to hearsay, to the statements being made by Jessica Marks in this video. We believe that they're out-of-court statements being used for the truth of the matter asserted.
Counsel, your response.
Yes, Your Honor. Although these are out-of-court statements, we're not offering them for any truth value they might hold, so it doesn't fall under the definition of hearsay under 801. We're just offering this video to show her actions.
Defense
Your Honor,
counsel.
Could the jury then be given a limiting instruction as to the statements that are made in this video?
Very well. We'll admit the exhibit and we will give the jury an appropriate instruction.
Yes, Your Honor.
The exhibit is admitted with instruction.
Now, Ms. Packman, could you play that video for the jury, please?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ms. Levin, did your server, Sunny, ever comment on how Jessica was acting?
Yeah, at some point, must have been during our last round, she came up and she pointed at Jessica and said, "I hope this one's not driving."
After she pointed at Jessica and said, "I hope this one's not driving," did she serve you more drinks?
Yeah, she handed us drinks.
Ms. Levin, what time did you and Jessica leave the bar?
Around 11:45.
And I know this may be difficult, but could you please tell the jury what happened after you and Jessica left the bar?
When we were leaving the bar, I took an Uber. I was behind Jess. She was driving down the highway. And her car, it swerved over the edge. And it fell off. I called 911, but she was dead, and I tried calling her and she didn't answer. Sorry.
Thank you, Ms. Levin. Your Honor, I have no further questions.
Counsel, you may cross-examine.
Ms. Levin, first of all, I'm truly sorry for your loss. I'm going to be asking you a few questions, and if you need a moment, please do let me know. Ms. Levin, you go to the University of California in Los Angeles, don't you?
I do.
You testified on direct examination that Jessica Marks was more intoxicated than you were, right?
She was.
But I want to look at Exhibit 17, what Ms. Judd showed you on direct examination. Could we have that put up on the screen, please? It says that the total was $119.58, doesn't it?
It does.
The gratuity was $20.
Yeah.
You said that totaled to $149.58, right?
That's what I wrote. Yeah.
Your Honor, we'd like to take judicial notice of the fact that $119.58 plus $20 is actually $139.58.
Counsel, do you have any objection?
No objection, Your Honor.
Very well, we'll note that on the record.
Ms. Levin, so isn't it a fact that you weren't able to add $119.58 plus $20 that night, March 24th, 2018?
I don't remember not being able to add.
Well, let's talk about other things you may not remember from that night, Ms. Levin. Ms. Levin, you don't remember where the other 10 people on the rooftop at Sonny's Rooftop Bar were sitting that night, right?
I wasn't really paying attention to everyone else, no.
You don't remember how much you and Jessica ate exactly that night, right?
We had chips and guac at the bar, but I don't remember how much exactly. Oh.
You don't remember which drinks were ordered where?
I mean, we ordered on the rooftop and some at the bar.
You don't remember what Sonny was wearing that night, do you?
No, I don't. I only interacted. I didn't remember.
You don't remember what Sonny's voice was like that night, right?
Of course not, no.
Your Honor, we'd now like to read a portion from the deposition of Stevie Redger, a witness from that night. Could that please be put on the screen? Question. We're here to talk about an incident that occurred on March 24th, 2019. Where were you around 9 p.m. that night?
Answer. Sonny, watching the end of the Lakers-Kings game.
Question. Tell me every drink you saw her have.
Answer. She had a couple White Claws. She had a beer or two. There was a bottle of wine on the table. I think she had a couple glasses of red wine.
Question. And her friend?
Answer. Same, plus maybe more.
This can be taken down. I want to talk about why you're here today, or why this lawsuit was even filed, Ms. Levin. As soon as Jessica Marks died, Ethel Marks, her mother, said that she was going to sue you, right?
She told me that, but she never did.
She said that you were the one who should have stopped Jessica from drinking and driving that night, right?
I feel like that every day when she's not with me.
It was only after this happened that you're here testifying for the plaintiff, right?
I'm here to tell you about what happened to Jessica.
But Ms. Marks didn't just point her fingers immediately at you, did she?
I'm sorry, I don't know what you mean.
Well, could we have what's been pre-admitted as Exhibit 23 put up on the screen? Now, it says here that as soon as the officer informed Ethel Marks of the situation, Ethel Marks said she, quote, would do anything she needed to do to make sure the bar would be held responsible. Did I read that correctly?
That's what it says.
Anything she needed to do to hold the bar responsible. Now, just to be clear, Ms. Levin, to your knowledge, Ethel Marks pointed at both you to be held responsible and Sonny's Rooftop Bar to be held responsible, but to your knowledge, not once at her daughter's own choices?
Objection, Your Honor, confusing the issues under 403. I believe Your Honor's muted.
Sorry about that. I was coughing. Usually I'm not muted. Go ahead, counsel. Please explain your objection.
Your Honor, opposing counsel is bringing up the fact that Ethel Marks tried to blame Morgan Levin for the death of Jessica Marks. Your Honor, earlier, before this trial started, the defense tried to bring up a contributory negligence as it relates to Ms. Levin, but that was denied. For the jury to hear any negligence on Ms. Levin's part about if she had any fault in Jessica Marks's death is confusing the issues for the jury.
Defense
Your Honor,
counsel.
Well, two things, Your Honor. For starters, Rule 403 sets the bar really high for prejudicial evidence. We believe that this doesn't meet that bar. It might be, in fact, confusing to one member of the jury, for example, but that's not substantial enough for the evidence to be excluded. Second of all, Your Honor, the reason we're using this line of questioning is actually to show that the lawsuit Ethel Marks has filed is fundamentally flawed, that from the very beginning, Ethel Marks decided to point at everything except for the choices her daughter made. We're using this line of questioning to show that the plaintiff is so blinded by the need to blame everyone except for Jessica Marks that the plaintiff will never recognize that it was Jessica Marks's own choices that killed her that night.
Well, I think to some extent, counsel, your argument there points to issues that we can't go into in this trial, because what we're interested in is facts, not and the witness has to provide us with facts and not philosophy on what's going on here. I will let you ask the question or ask concerning the subject you're interested in, but quite frankly, I think your question was confusing. So to the extent I think your question was confusing, I'm going to sustain counsel's objection and I'll allow you to inquire into the subject, but you're going to have to rephrase the question, and counsel may object again depending on how you rephrase it. So you may at this time inquire into the subject. You just have to rephrase the question so it's not quite so convoluted.
Yes, Your Honor, I'd be more than happy to do so. Now, Ms. Levin, to your knowledge, Ethel Marks never said, quote, it was Jessica's own choices that led to her death, did she?
No, she didn't say that to me.
Well, let's talk a little bit more about Jessica's choices from that night. It was Jessica's choice to create and purchase fake IDs for the two of you, wasn't it?
Objection, Your Honor, lack of personal knowledge.
Defense
Your
counsel,
Honor.
your response?
Your Honor, pursuant to Rule 701A, I'm inquiring as to the witness's rationally based perception. She can perceive whether or not it was Jessica Marks's conscious decision to get a fake ID and bring it to Morgan Levin when they met up.
I'm going to sustain the objection on the grounds that I think it needs to be rephrased, but I'll allow you to inquire into the subject you're interested in. But I think you need to rephrase the question. So to that extent, I'm sustaining the objection, but counsel, you may rephrase the question.
Yes, Your Honor. To your knowledge, Ms. Levin, it was Jessica's choice to bring fake IDs for the two of you, right?
Objection, Your Honor, there's a lack of foundation, if I may explain.
I'm going to overrule that objection. We'll allow it. We'll see what the witness says.
Yes, Your Honor.
Sorry, can you repeat the question?
Of course. To your knowledge, it was Jessica's decision to bring fake IDs for the two of you, right?
I don't know. I mean, I guess.
To your knowledge, it was Jessica's own decision to drive her Chevy Impala to Sunny's rooftop bar, right?
Well, we wanted to go to the bar, so she drove us.
To your knowledge, it was Jessica's own choice to order those drinks using her fake ID.
We ordered them together at the bar, and the bar served us.
But that's a yes to my question. To the best of your knowledge, it appeared to be Jessica's own conscious decision to order these drinks using her fake ID.
Sure, we ordered the drinks.
And it was Jessica's own choice, her own conscious decision, to your knowledge, to not take that Uber with you when you all left the bar, right?
She said she was fine, and I believed her for a second.
To your knowledge, Miss Levin, are you finished?
Yeah.
To your knowledge, it was Jessica's own decision to get behind the wheel of her car despite drinking that night, right?
She drove. I told her I was taking an Uber and she could come with me. But she drove.
No further questions.
Plaintiff counsel, is there redirect?
There's no redirect, Your Honor, and we ask that the witness be allowed to step down.
Very well, the witness is excused.
And Your Honor, before the plaintiff rests, we'd like to read a portion of a pre-admitted exhibit, Exhibit 22.
You may do so. Remember, the time clock is running.
Yes, Your Honor. Ms. Packman, if we could get that on screen. The subject is a normally developed 19-year-old white female, and under toxicology, blood drawn at scene of accident contains 0.16 grams per 100 milliliter of blood, the BAC. Thank you, Ms. Packman, you can take that off screen. And with that, Your Honor, the plaintiff rests.
Very well. Defense, you may call your witness.
Your Honor, at this time, the defense calls Sunny Mehta to the stand.
The witness is called.
Ms. Mehta, please introduce yourself to the jury.
Hi, my name's Sunny Mehta.
What do you do?
Well, I used to own a bar called Sunny's Rooftop Bar, women in business, but I sadly had to give up that job, and I'm currently in between jobs looking for my next profession. Hopefully it could be just as great.
What is Sunny's Rooftop Bar?
Well, like I said, it's a bar in California, and it's, what a bar is. People come, they drink, they eat, they have fun, and they go home.
Now, Ms. Mehta, do you know who Jessica Marks is?
Yes, I do. She came to my bar the night of March 24th, 2019.
Was she with anyone?
She was. She was with Morgan Levin.
Well, let's start from the beginning on that night of March 24th, 2019. What time did Jessica come in?
She came in around 9 o'clock, and when her and Morgan came in, they seemed perfectly fine, perfectly sober. They came in, walked straight up to the rooftop.
Who was working at the bar that night?
It was just me and Frankfurt Johnson. He was behind the bar. He was getting all the drinks, and I was serving the customers and talking to them. I honestly think that's the best part of my job, just getting to meet everybody who comes by, tell them what Sunny's is really about.
Did you serve Jessica Marks and Morgan Levin alcohol that night?
Yes, I did. It was a Sunday night, so it wasn't a busy evening. So I was there all night, and they were two of my customers.
And about how many times did you go over to Sunny and Jessica that night?
I went over to their table about 10 times that night.
Did you see how Jessica was acting throughout the night?
Yeah, she seemed completely fine. It was nothing out of the ordinary to me.
Did she seem to get more and more intoxicated throughout the course of the night?
No, I mean, she kept drinking, so of course she was getting a little more buzzed, but I would never say she seemed obviously intoxicated.
Well, how do you know what obviously intoxicated is?
Well, we have to go through state-approved responsible beverage service courses every 3 years due to the state of California. Me and all my employees have to take it, and I make sure we all do because we don't want to be getting in trouble. And most importantly, we want to be keeping our, customers safe. And in this course, we learn about how alcohol impacts the body, how to recognize the symptoms of obvious intoxication, and the fact that you can't serve anybody younger than 21 and how to make sure that you're not doing it.
What are those symptoms of obvious intoxication that you look for?
Well, there's a list, and usually you match them up to see what someone is displaying and also their tolerance, their body weight, their height, everything goes into it. There's not an exact formula, but normally you can look for red eyes, watery eyes, a vacant gaze, flushed cheeks, heavy stench of alcohol, loss of balance, any trouble standing, lack of hand-eye coordination, slurred speech, talking loudly, not making sense, and of course, if they're passed out.
I want to talk about these signs in context of Jessica Marks. At any point throughout the night, did you see Jessica's eyes as watery?
No, I never saw them as watery. If I had, I would have cut her off.
At any point throughout the night, did you see Jessica's eyes as red?
No, I didn't.
At any point throughout the night, did you see Jessica Marks slurring her words?
No, anytime I interacted with Jessica, she was just ordering drinks and she was never slurring her words.
At any point throughout the night, did you see Jessica Marks get really loud?
No, nothing out of the ordinary. She was talking like she would at any bar.
At any point throughout the
Objection,
night?
Your Honor, lack of foundation and speculation.
Counsel,
Honor,
your
if I-
response to the objection?
Your Honor, again, pursuant to Rule 701A, I asked Miss Mehta to testify to what she knows, what she was able to see. Did she see Jessica Marks get really loud? Did she hear Jessica Marks get really loud? These questions are calling for Ms. Mehta's rationally based perception, and that's why she does have the personal knowledge to testify to what she can see, to what she can hear.
Counsel, your objection, your response?
Yes, Your Honor, I wasn't objecting to opposing counsel's question. I was objecting to the witness's answer. She told us that Jessica Marks was speaking as loud as she would at any bar. Your Honor, we heard the witness say that March 24th was the first time that she ever met Miss Marks. She would have no way of knowing how Miss Marks usually acts at other bars. So as of right now, she's speculating.
Your Honor, if I may.
You may.
I believe that Ms. Mehta is just referring to generally speaking. Miss Marks was speaking as loud as she would at any bar, meaning that any arbitrary person at that bar was speaking just as loud as her. Ms. Mehta has owned Sunny's Rooftop Bar for quite a while as we've laid that foundation, and she knows generally how loud people are talking. That's what Ms. Mehta was referring to, Your Honor. She wasn't speculating on Jessica Marks. She was using her experience in dealing with clients to determine what exactly really loud is. And she believed that it wasn't above or below that norm.
I'm going to overrule the objection. Counsel, you can cross-examine on that subject.
Yes, Your Honor.
Ms. Mehta, at any point throughout the night, did you see Jessica Marks lose her coordination?
No, never. She never fell on me. I never saw her stumble. Not at all.
Now, I want to talk about that friend you said Jessica was with. Have you been in court today?
Yes, I have.
Did you hear Morgan Levin testify earlier today?
Yes, I was here for that.
Now, Morgan Levin said that said that Jessica Marks tripped down the stairs and into your arms. Did that happen?
No, it didn't. And if it did, I would have cut Jessica off. That's one of the clear signs of intoxication.
Morgan Levin said that you said we might have to cut this one off. In reference to Jessica. Did you say that?
No, I didn't.
Morgan Levin said that you said in context of Jessica Marks, I hope this one's not driving. Did you say that?
No, I didn't say that. If I did, I would have taken her keys and not let her drive. I care about my customers.
Well, let's talk about Morgan Levin for a second here. How was Morgan Levin acting throughout the course of the night?
Well, she actually looked sleepy. I noticed that her eyes were in fact bloodshot and she did in fact trip over her words.
To be clear, Ms. Mehta, at any point, did you ever serve Jessica Marks alcohol if she was obviously intoxicated to you?
No, I wouldn't have. I never serve anybody that seems obviously intoxicated.
Objection, Your Honor, inadmissible character evidence under 404.
Please explain your objection, counsel.
Yes, Your Honor. The witness just testified that she's never served anyone who's obviously intoxicated. This is inadmissible character evidence because it's showing that because if in one instance she never served someone who was obviously intoxicated, it makes it more likely that in this instance, she also didn't serve someone who was obviously intoxicated.
Counsel, your response to the objection.
Your Honor, I believe that Ms. Mehta was simply testifying to what her experience has been, that she has owned the bar for a certain amount of time. And in that amount of time, she has never served anyone. She has never overserved anyone. I believe that she's not using this for propensity. She's simply laying the foundation to how she was able to make the decision to continue to serve Jessica Marks that night.
Plaintiff counsel, do you have any more?
Yes, Your Honor. It's specifically because this witness is testifying that in any amount of time she's worked at her bar, she's never served someone who's obviously intoxicated. Your Honor, that's why it is character evidence. It's showing propensity for that one instance and on March 24th.
Defense counsel, do you have any more?
Again, Your Honor, pursuant to Rule 404, we believe that Ms. Mehta is simply using this to outline the number of times that this has happened before in her experience. And furthermore, Your Honor, pursuant to Rule 406, this is actually a habit or routine practice of Sunny's Rooftop Bar that we believe Ms. Mehta is testifying to. We don't believe that it's necessarily saying propensity for Ms. Mehta specifically, but it's just a habit or routine practice that she and her organization do.
I'm going to overrule the objection. We'll allow it.
Now, no further questions at this time, Your Honor, but we would like to read out from the deposition of Stevie Redger. Question, did you ever see Jessica stand up?
Answer, probably. She was there a couple hours, but I didn't see her fall or stumble, if that's what you're getting at.
Question, had you ever seen Sunny's refuse to serve someone?
Answer, yes, if the person was drunk. Saw it several times.
Question, ever seen Sunny's take someone's keys, call them a cab?
Answer, oh, sure. Sunny and the employees were very responsible.
Objection, Your Honor, inadmissible character evidence.
To that last answer, the fact that the employees were very responsible,
Yes, Your Honor.
I'll sustain that. We'll strike that.
Nothing further, Your Honor.
Cross-examination.
Yes, you may proceed with your cross-examination.
Good afternoon, Ms. Mehta.
Good afternoon.
Now, I want to start by talking about the signs of obvious intoxication. Now, you've been specifically trained in how to notice those signs, right?
Yes, I have.
You know the signs to look for.
Yes, I believe I mentioned them on direct.
That's right. Now, one of those signs could be loss of balance, right?
Yes, it is.
Red, watery eyes,
Yep.
slurred speech,
Yes.
a flushed face.
Yes, I said all those.
Now, if there is an obviously intoxicated person in your bar, you'd be required by law to stop serving them alcohol, right?
Yes, that's true.
If you were to ignore those signs and serve them anyway, you'd be breaking the law, right?
Yes, all that is correct.
Well, now I want to talk about if Jessica Marks showed any of those signs on March 24th. Now, you told us on direct examination that you didn't see any signs of intoxication in Miss Marks, right?
No, I didn't. I never saw any of these signs. If not, I would have cut her off.
Miss Mehta, March 24th was the very first time you'd ever seen Miss Marks, right?
That's true. However, when she walked into the bar at 9, she seemed completely sober.
Well, I'm not asking how she acted when she walked into the bar. Just asked if you'd seen her before. You never had.
No, I told you I hadn't.
You've never seen how she interacted with people at other bars?
No, I don't need to.
Now, you were serving Miss Marks for almost 3 hours that night, right?
Yes, I was. They came in at 9 and left around 11:45.
And you took her order about 4 to 5 times?
Yes, and I was at their table about 8 to 10.
That's right. You were at their table as many as 10 times, right?
Yes,
But you listened to Jessica as she was ordering.
yes, that's true.
You could even tell she had a bit of an accent, right?
Yeah,
Now, Miss Mehta, I'm going to play a video that was taken of Miss Marks that night. Miss Packman, could we get Exhibit 10 on screen? And could you play that?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Miss Mehta, you recognize the girl in that video as Jessica Marks, the one you served on March 24th, right?
yes, I do.
And from what you can see, this video was taken at your bar, right?
Yes, it was.
Now, you'd agree, Miss Meta, that in this video, Miss Marks looks drunk.
Well, she was being loud and she wasn't making a lot of sense.
So is that a yes? She looks drunk?
Yes,
If you were standing there and you saw Miss Marks acting the way she was in this video, you might have cut her off, right?
I most definitely would have.
If you saw her acting like that, you would have been concerned for her.
Yes.
Objection, Your Honor. I believe that these hypothetical questions that Ms. Judd is asking, they call on the witness's lack of personal knowledge pursuant to Rule 602. Ms. Mehta only knows what she saw. She didn't see this video, and that's why she didn't see the way that Jessica Marks appears to be acting in this video, and that's why she can't testify to hypotheticals. She's not an expert witness in this case.
Counsel, your response to the objection.
Yes, Your Honor, I am asking the witness about her knowledge of this video. It's our contention that Jessica Marks was acting this way throughout the night on March 24th. Therefore, it's highly relevant to hear whether or not the witness would have cut her off if she was acting the way she did in this video.
I'm going to sustain the objection. You can ask the witness questions about the video or whether the witness saw this video or saw the witness acting this way, but the hypothetical questions as to would you have cut the drinks off at some point are hypothetical. So I'm going to sustain objection to hypothetical questions, but you certainly may ask questions about this video and what the witness sees or has seen.
Your Honor, move to strike the hypothetical questions from the record.
Will do so. Stricken.
So, Ms. Mehta, the way that Jessica Marks is acting in this video is concerning to you, right?
Yes, it is.
Now, you're aware that Jessica Marks's blood alcohol content was found to be 0.16 at the time of her death, right?
Yes, I am.
That's just minutes after she left your bar?
Yes. I mean, it's tragic what happened, but it was after she left. She made the choice to drive home.
Ms. Mehta, I'm not asking if it was her choice. I just asked if minutes after Miss Marks left your bar, her blood alcohol content was 0.16. It was, right?
I told you yes in the last response, so yes.
Well, I just want to make things clear for the jury. On March 24th, you never cut off Jessica Marks, right?
No, I didn't, because I never saw her acting the way she did in the video. I never saw her display any of the symptoms. And if I had, of course I would have cut her off.
Miss Mehta, I wasn't asking about the video. You never cut off Miss Marks that night, did you?
I told you I didn't because I didn't need to. I never saw her act obviously intoxicated.
So every time Miss Marks asked you for more alcohol, you gave it to her.
I mean, yeah, I did. It's my job. She orders. I bring her the drinks.
Thank you, Miss Mehta. Your Honor, I have nothing further.
Counsel, do you have redirect?
Yes, Your Honor, but before I proceed with that, I'd like to inquire as to how much time I have remaining.
You have 1 minute and 31 seconds remaining.
Okay, sounds good. Now, Ms. Mehta, Ms. Judd just showed you a video, Exhibit 10. Do you remember that?
Yes, I do.
Did you ever see, were you there when that video was being recorded?
No, I was nowhere there. And like I said, I never saw her acting like that. And if I had, I would have immediately cut her off. It was concerning to me what I saw in that video, but she never showed any of that to me. So I couldn't have known.
Ms. Judd talked a little bit more about blood alcohol concentration. Did you measure, were you supposed to measure Jessica Marks's blood alcohol concentration before she left the bar?
No, there was no way for me to have done that. So, no.
No further questions.
Counsel, is there recross?
No recross, Your Honor.
Very well. The witness is excused. It is now time for closing arguments. Does anybody need a break before closings? Normally we don't take a break, but if somebody needed a break, we could do so. Or if we're ready, then we can proceed directly to closings.
The plaintiff is ready to proceed.
The defense is also ready to proceed, Your Honor.
Very well, let's switch to speaker view. Plaintiff. Okay, somehow or other, my Zoom screen all blanked out and then it came back.
Yes, Your Honor. I believe some of us got kicked out for a moment. If we want to take a second to make sure everyone's here.
I see the. Very well. Plaintiff counsel, you may be on screen and present your closing.
Yes, Your Honor. They ignored the obvious. The obvious. The signs of intoxication. Members of the jury, today you've been provided with a list of some of those signs. Signs that the defendant ignored. Loss of balance, red, watery eyes, loud conduct, slurred speech, flushed face. Now, some of those things, they aren't especially obvious. It's not always easy to tell if someone has an unnaturally flushed face or not. But nonetheless, members of the jury, the defendants were specifically trained to pick up on even those subtle details because it was their job. But in this case, the defendant didn't just miss subtle signs of intoxication. You saw the video today. This was obvious. And they ignored the obvious. And that's why today we brought a claim of wrongful death against the defendant, Sonny's Rooftop Bar. As the plaintiff, we had the burden to prove the following elements. That while Jessica Marks was a minor, the defendant saw the signs that she was intoxicated and continued to serve her alcohol, which was a substantial factor in causing her death. Now, we proved to you today that those signs were obvious and that the defendant ignored them. So let's walk through how we proved that right now. First, the signs were obvious. Morgan Levin told you today that Jessica was clearly acting intoxicated, and she only got more drunk as the night went on, which makes sense because you saw the list of drinks that Jessica was served. But no, you don't have to just take Morgan Levin's word for it. You got to see with your own eyes how Jessica was acting in that video today. Slurring her words, not making sense, dropping her can, struggling to pick it back up again. Those are obvious signs of intoxication. Now, Sunny Mehta wants you to believe that she didn't see any of those signs. But when confronted with the facts of the video on cross-examination, the defendant changed her mind. Ms. Mehta told us that in that video, Miss Marks looked drunk. She said in that video, she would be concerned for Miss Marks. Well, members of the jury, we know that Miss Mehta was around Miss Marks when she was acting like that. That video was taken at about 11 p.m. And Miss Mehta told you today that she was at Jessica's table as many as 10 times before and after that video was taken. Now, when you go back to deliberate, you're going to have that video. And I want you to take a look at the time signature. It's 37 seconds. Now, as we learned today, you can tell a lot in even just 30 seconds, especially if you're trained to look for the signs. And those signs were obvious. They saw them. Which brings us to the second fact that proves them liable. Even though they saw the signs, they ignored them. Even after Jessica Marks stumbled down the stairs into the defendant, and the defendant said, "We should cut this one off," they took her order again and brought her more alcohol. Members of the jury, the defendant told you on the stand today, it's their legal duty to cut off customers when they're drunk. They knew their duty, but they ignored it. The defense tried to present evidence to you today, telling you that this is all about Jessica's choices. She made the choice to drink and drive, so she's responsible. But members of the jury, if they stop serving her, she drives home safe. That's this case. It's why this law exists. That people who are drunk don't make the best decisions. They're impaired. So bars are required to stop serving them. And that's not when they're fall down drunk, members of the jury. The point of the law is to stop them before they get to the point that Jessica Marks was at. The law says that the bar is responsible, not the kid who tried to order some drinks with a friend. Jessica Marks was just 19, still in college with her whole life ahead of her. And if the defendant had done what they were trained to do, what the law required them to do, for all we know, she would have lived that life. They ignored the obvious, but members of the jury, we're asking you not to. We're asking you to find the defendant liable for the wrongful death of Jessica Marks. Thank you.
Defense counsel, you may come on screen and deliver your closing.
Yes, Your Honor. Ms. Judd just came before you and she told you that Sonny's rooftop bar saw the signs but chose to ignore them. And to that, I'll give you a number, 10. 10 times. 10 times, that's the number of times Sonny Mehta testified today that Sonny Mehta came over to Jessica Marks's and Morgan Levin's tables. 10 times. You can ignore something one time, members of the jury. You can ignore something 2 times, but 10 times. The plaintiff expects you to believe that Sonny Mehta ignored the signs of obvious intoxication, of public inebriation by Jessica Marks 10 different times. That's not reasonable. That's not more likely than not. The plaintiff is choosing to distort the facts. Let's talk about what they had to prove and what they want you to believe. See, they had to prove that Jessica Marks was obviously intoxicated that night and that she was showing the signs of obvious intoxication. They had to prove that by a preponderance of the evidence that it was more likely than not that this was happening. That's what they want you to believe. They want you to believe that, and yet what did they show you? Nothing. Jessica Marks wasn't showing those signs of obvious intoxication because, as you heard from Sonny Mehta, she went over 10 times to their table and not once did she see them showing those signs. They couldn't prove that Sonny Mehta ever measured her blood alcohol concentration and chose to ignore it. Couldn't show you that Sonny Mehta knew Jessica was slurring her words, had red eyes, and chose to ignore it. They couldn't show you anything. They want you to believe that Jessica Marks drank enough alcohol that night to be obviously intoxicated, but did they show you any videos of her drinking? Did they show you any pictures of Jessica Marks actually drinking the alcohol Morgan Levin said she did? They didn't, because those don't exist, because it never happened, members of the jury. Now, today's case isn't about what they want you to believe or what they had to prove. It's about what you believe. Now, I said at the very beginning of today's trial that I'd answer 3 questions. 3 questions that would show you how fragmented the plaintiff's case is today. And let's start with that first one. Why did Sonny's Rooftop Bar choose to serve Jessica Marks? And the answer to that is simple. Because she wasn't showing any symptoms. You heard that from Sonny Mehta. You heard that from Stevie Redger. See, Sonny Mehta comes to the stand and says that she went to their table 10 times, as we talked about earlier, and not a single one of those times was Jessica Marks showing watery eyes, red eyes, slurred speech, being loud, having a loss of coordination. I mean, how was Sonny Mehta supposed to ignore the signs if she didn't see them, members of the jury? Why is the plaintiff choosing to tell you that Sani Mehta saw the signs when she so clearly told you she didn't see them? Does the plaintiff believe that Sani Mehta had to read Jessica's mind? Does the plaintiff believe that Sani Mehta had to be psychic in order to see Jessica Marks as obviously intoxicated? Is the plaintiff asking you to believe in the supernatural in order to believe in their case? Because that's not reasonable, that's not preponderance of the evidence, and that's not more likely than not, members of the jury. And it's not just Sani Mehta, it's Stevie Reger too. Stevie Reger has said, I didn't see her fall or stumble, if that's what you're getting at, because that's exactly what happened. Stevie Reger doesn't have any stake in today's case. Stevie Reger's not lying when he says that. You also heard Stevie Reger say that Sani refuses to serve people. Sani refuses to serve people, and they've done that plenty of times. So why would they choose not to do it this time? Well, it's because they didn't see the signs. They chose to continue to serve her because they weren't ignoring anything. Which brings us to the second question. What is Morgan Levin choosing to hide? Because you heard from Sani Mehta today that there were two people at that table, right? It was Morgan Levin and Jessica Marks. And of the two people at that table, you heard that it was Morgan Levin who looked a little sleepier. Of the two people at that table, you heard that it was Morgan Levin whose eyes got a little more bloodshot. And of the two people at that table, you heard that it was Morgan Levin who tripped over her words. And today you even saw Morgan Levin, a student at the University of California, Los Angeles, couldn't do basic math that night. The only reasonable explanation for that is that she was drunk. And don't just take it from me, take it from Stevie Reger, who said that Jessica's friend, Morgan, likely had the same amount of drinks, plus maybe more. And now that third question. Let's say for a second that you believe it. You believe that Sani Mehta had to be a psychic in order to look at Jessica Marks's symptoms of obvious intoxication. You believe every lie that came out of Morgan Levin's mouth. Even then, the job's not finished. Because the law says that if you believe the plaintiff has met their burden today, well, then you have to ask yourself that final question. You have to take into consideration our affirmative defense. Whose choices ultimately led to Jessica's death? And we showed you today, it was Jessica's choice to drive in her Chevy Impala to Sunny's rooftop bar, knowing she was going to drink that. It was Jessica's choice to get a fake ID and to order those drinks illegally. It was Jessica's choice to not get in the Uber with Morgan Levin and to instead get behind the wheel despite having drank that night. Now, members of the jury, when someone close to us dies, what's the natural response? The natural response is for us to grieve, for us to find someone to blame. And that's exactly what's happening here today. You heard from Morgan Levin that the moment this lawsuit was filed, Ethel Marks said she would do anything she needed to make sure the bar would be held responsible. Without even knowing the full context of the situation, of what happened that night, of what her daughter's choices were, she said she would do anything to hold the bar responsible. And that's what they're doing today. They're grasping for straws. They're doing anything they can to put a small business back into the shadows. I've talked a lot about choices throughout the course of today's trial. And I said that now you have a choice to make, because you do. You can choose to not give in to that emotion that was brought to you today. You can choose to not punish Sunny's Rooftop Bar for doing everything they needed to do. Today, you can choose to find Sunny's Rooftop Bar not liable. We're confident you'll make the right choice today. Thank you.
Thank you, counsel. Plaintiff counsel, do you have a rebuttal? And timekeepers, how much time is available for plaintiff's rebuttal?
Per my time, plaintiff has 1 minute and 10 seconds remaining.
Very well. Plaintiff, your rebuttal, 1 minute and 10 seconds.
Yes, Your Honor. No, but we agree. This case does come down to choices, but not the choices of Jessica Marks. Because after Miss Marks was served drink after drink, her choices were stripped away from her. And it came down to the choices of the defendant. And even after the defendant saw the signs, even after Miss Marks fell into the defendant, stumbling and slurring her words, the defendant made the choice to ignore those signs and serve her anyway. And it's because of that choice we ask that you find Sunny's Bar liable. Thank you.
Okay, that concludes the trial. Could I ask everyone to switch to gallery view? And could I ask all participants to come on screen? It helps to associate names and faces for the judges as we do scoring. So if we could see both counsel and both witnesses as we do our scoring. When the scoring judges have submitted their ballots, I'll ask them to come on screen. I'm going to go complete my ballot now, and when all of us have completed our ballots, we'll have comments. So I'd ask the scoring judges to come back on screen once they've submitted their ballots.